Welcome to Case by Case, a podcast brought to you by Calum Chain and Luke Zadkovich from Zyla Floyd Zadkovich. We're delighted to have you listening in for today's episode. Welcome, Calum.
Hey, Luke. Good to be back.
Yeah, always good. I look forward to doing this each week.
Yeah, me too.
Yeah, it's what is it? I think we're into our fifth or so now. So we're getting there. And before we get into this one, it's been remiss of us, I suppose, that we haven't to date given a big thanks to Rachel, our marketing officer, Rachel Tenenbaum, who helps us with the editing and the marketing efforts. So thank you very much, Rachel, for all your help.
Totally agree. We wouldn't have anything without Rachel. So big high five to Rachel.
Absolutely. So consequential losses today, Calum.
Yeah, and as an early spoiler alert, this is the first case by case where I actually think I don't agree with the decision entirely.
I like it. It's interesting. I had a similar kind of reaction to it. I know you've looked at consequential losses recently and you're fully across this. But I haven't, in the last few months really focused on this as a topic. And when I read through the decision, I kind of had the same reaction. I was like, I'm not entirely sure about this one. So it sounds you're more emphatic than I am.
Yeah, I guess we'll go through it in detail, and there are a couple of different points. I maybe before we start, it's worth mentioning that this is a London Maritime Law Newsletter, London Arbitration Award, and for people who are not familiar with kind of reading judgments and reading arbitration awards, you get much less from a arbitration award, from a write-up. It's almost more designed just to give you an idea of the kind of cases that are in the market. They're extremely helpful because they show you the kind of decisions that arbitrators are making. They're not binding, they're non-binding, but they can be persuasive in other arbitrations. And people often do, in commercial discussions, rely on London Arbitration Awards to say, look, another tribunal has found this in this case, and that's analogous to our case, so we're going to win. But they're not binding authority, and I think they also are not completely detailed. I guess what I'm driving at is it's not the same as a judgment where you can read through and you can really see exactly why the judge has decided what they've decided. Here it's more just an abstract of the decision, so you don't benefit from the arbitrator's deliberations in the same way that you do in a judgment.
Yeah, it's almost a summary, isn't it? It's almost a summary of the decision. We don't get the parties. We don't know who the arbitrators are. We know that this was only recently reported, so it's in Lloyd's Maritime Law Newsletter on the 7th of May 2021. I think that's the date of publication, or is that the date of printing this this copy?
I think that's the date of publication. Early May, yeah.
Early May. Okay, so it's a recent decision. It's certainly worth talking about because it goes to this point about consequential damages and when they are excluded by contracts or not. And we'll get into the ins and outs of it. I always like cases that go back to Hadley and Baxendale. So we'll touch on that gem of a case from all those years ago. And before we do, why don't we get into the facts of this one? Even though we've got kind of short form facts, I think it's worth laying them out, Calum, for our listeners.
Yeah, absolutely. It at least contextualizes the discussion. So here we have a head charter party between owners and charterers, and the charterers sought to send the vessel on a final voyage. The owners said that the final voyage was not legitimate, presumably on the basis that the owners considered that the voyage could not be performed within the remaining period of the charter party, and they withdrew the vessel from the charter party. There weren't in this discussion. There wasn't actually any dispute about the about whether or not the voyage was legitimate. It was a preliminary issue hearing on different issues, so we didn't get into that at all. But charterers, rather than defend the claim with any sort of substantive defence, they brought a series of counterclaims, and they said, because you have withdrawn the vessel from the service wrongfully, we've suffered all these different losses. And their defence basically then existed in set-off of their counterclaim. And the three different heads of losses that they said they suffered, the first was the loss of hire under the sub-time charter party. The second was the loss of a right to a demobilisation fee of $150,000. And the third was a loss of the profit that they would have made under a renewal of the sub-time charter party, which was the big majority of their losses, and that was 1.8 million. The loss of hire and the right to the demobilisation fee together came to a little over 300,000. So, and owners had then asked for a preliminary issue. As a preliminary issue, owners had said, you're not entitled to claim these losses because they are consequential losses for the purposes of the charter party.
Just on that, before we get into looking at the preliminary issue hearing that was the subject of this hearing and decision, did you find it slightly odd that there were no specific defences raised to owners' claim, putting aside whether there were counterclaims or not?
I did. I found that bizarre, and I wondered if there was a subtext to all of this, that maybe charterers weren't fully engaged in the dispute in some way. It's really difficult often to read between the lines a little bit in these awards, but I got the feeling from the arbitrator that they hadn't been particularly impressed by charterers' kind of general conduct in the arbitration, not pleading things they ought to have pleaded, not bringing substantive defences, when you would have thought that they would have had substantive defences to owners' claims.
Well, if they had a counterclaim for repudiatory breach and wrongfully withdrawing the vessel, then I struggle to see why that wouldn't operate as a defence to the claim, at a minimum, putting aside whether the counterclaims are excluded because of the consequential loss exclusion clause.
Yeah, exactly.
I was at a loss when I read it, to be honest, to understand how that worked, whether it was a pleading failure, whether it was more substantive. Obviously, we don't know from what we've seen here in this decision, but that was kind of one point that jumped out at me. So what we're talking about here is a preliminary issue hearing, and for those of you that are not familiar with London arbitration procedure, what can happen, and this can be on the request of either party or by consent of both parties, that an issue or issues get put before the arbitrators at a preliminary stage. It's almost like, think about a summary judgment or a motion to dismiss type situation where there's some threshold issue that might dispense with the overall claim without having to go through full discovery and disclosure, full expert evidence, all those things, like we have here, where there's an exclusionary clause which owners say applies and cuts out all of the consequential losses or alleged consequential losses that are being claimed by the charterers. So it's a point of law, it's construction of a clause, and whether the claims fall within this clause and are excluded or not.
Yeah, and maybe we should just go straight on to the clause. And it's nice, again, it's not clear whether this clause, and this is one of the points where I question this decision, that it's not clear whether this clause was the basis of the tribunal's decision that the losses were consequential. Anyway, there's a consequential damages exclusion which reads, consequential damages, neither party shall be liable to the other party for any consequential damages whatsoever arising out of or in connection with the performance or non-performance of this charter party. And then somewhere else in the charter party, it says, consequential damages shall include, but not be limited to, loss of use, loss of profits, shut-in, loss of production and cost of insurance, whether or not foreseeable at the date of this charter party. And the decision ultimately was that these three heads of losses were all consequential losses, and therefore they were excluded by the consequential damages provision. The question I have is the treatment of the second part, where it kind of defines or states what consequential damages will include. And I think the best way to look at this and to kind of break it down is to go back to just what are consequential losses under English law, and that's the decision that you spoke about at the start, Luke, Hadley and Baxendale, which is
1864, Calum.
Exactly.
1864.
And,
and it's as good today as it ever has been. And maybe because we've all dealt with Hadley and Baxendale over the years, and it's one of those cases, Donahue and Stevenson, that you do in law school on day one kind of thing. But then keeps popping up at other times throughout your career. And the two main limbs under Hadley and Baxendale are, you've got your direct losses, your direct damages, which are recoverable, and then the second limb, which is what we're talking about today, are those losses that may have been in contemplation of the parties at the time they entered into the contract. And I've always thought it's a really interesting concept under English law in a damages context to think, well, there are damages that flow directly from a breach. So you can say, okay, you breach the contract, it's very clear that this is going to be the consequence, and those damages flow directly from the breach. But then there's this other set, this second limb, where you take the parties back to the moment upon which they entered into the contract, and you say, well, if the contract was breached in this way, would those damages have been reasonably contemplated at that time, at the time of formation? And I've always thought about this and advised clients over the years. It's often going to be helpful if you're in the situation where you're going to want to recover some damages because you've got, in this case, a sub-charter party, or you've got some other further contract that's going to be impacted if this one isn't honoured. Tell your counterparty about it.
Yeah.
Let them know what's going to happen. Be in your negotiations. Say, look, I've got this. Don't have to give away the exact details. Query that, but just give at least sufficient information to say, I've got this subsequent charter. I'm going to be earning a good profit on that. You need to make sure you're going to honour this contract. Otherwise, I'm going to suffer further losses. Put them on notice, and then those subsequent losses could be, at least arguably, could be within reasonable contemplation of the parties. And it's that very limb, or that set of damages where one party might almost, nonchalantly or discreetly putting the other party on notice of other losses that might be suffered that don't necessarily flow directly from the breach, that these exclusionary clauses go to excluding.
Right, exactly. And that's, I think, a critically important point on consequential losses, because we look at consequential losses a lot, and we kind of, I think maybe commercially, that it's one of these issues where I think there's a dissonance between the strict legal interpretation of what a consequential loss is and what people commercially think of as a consequential loss. And in legal terms, it's well settled up to the Supreme Court level that Hadley and Baxendale is good law, which means you have two different types of losses that you can claim. You can claim losses that flow directly from the breach, or you can claim losses that the parties were in the contemplation of the parties at the time of contracting. You can't claim anything else. So what you're protecting yourself from normally with a consequential losses clause, with a clause that simply says consequential losses are not recoverable, it's that second limb of damages. The things that you're excluding are losses that were in the contemplation of the parties, but don't flow directly from the breach. So looking at it in that light, if we go back to the losses that were claimed, I'm not certain which of these is a consequential loss, applying applying Hadley and Baxendale. So the first is The first is hire under the subcharter party, which perhaps we'll come back to because that's, I think, the most contentious one. The second is the demobilisation fee of $150,000, and the third is the loss of profit for the onward renewal of the charter party. And to me, the second and third category are simply too remote. I don't think the consequential loss clause comes into it. I think they fail because they're too remote to be claimed as damages. They're neither limb of Hadley and Baxendale.
Yeah, there must be something to that. When I saw, I didn't focus on the second one so much, the demobilisation fee, but I can see your point there. But particularly the third one, to say that some renewal of the subcharter is connected to the head charter, I found that jarring as a claim, and I think you're right. I think it goes to the question of remoteness. Now, if the damages are too remote, then they don't even get into the second limb so as to be excluded.
Exactly. So you get to the same place as the decision, but you get there slightly more directly, because what Hadley and Baxendale was really talking about, or what the case of Hadley and Baxendale was really discussing, was what type of losses are recoverable under English law. And you have losses that flow directly, and you have losses that the parties were aware of. And commercially, parties now say, that second bucket of losses, we want to exclude those. We don't really care about what we said in contractual negotiations. If the losses don't flow directly from the breach, we want them to be excluded. But those losses, particularly that loss of profit for a notional renewal of a charter party that didn't happen, to me, that's just too remote. It doesn't come into the question of consequential losses. The one which I think is very interesting is the question of hire under that subcharter party. Whether that hire is consequential, and there's authority in the context of maintenance disputes. So if I'm an owner and you're a charterer, and you're chartering my vessel, and I fail to maintain that vessel to the standard required of me under the charter party, and as a result of that failure, you then miss one of your fixtures, there's commercial court authority, it's called the Sylvia. There's commercial court authority that the loss of hire that you suffered is a direct loss. So to me, under the normal position, those are direct losses. And the interesting question here is whether they're brought into the category of consequential losses for the purposes of this charter party by the wording that is also included in the charter party that says consequential damages shall include, but not be limited to, loss of use, loss of profits, etc.
Yeah. And does this go to that point about whether the list of types of consequential damages that are expressly stated in the clause are limited by the concept of consequential damages? So what I mean by that is that when you have a definition, which is what this is, consequential damages shall include but not be limited to loss of use, loss of profit, shut-in, or loss of production and costs of insurance. There could have been others, and we see other descriptors in other types of definition clauses. But I've always understood it that those individual descriptions have to fall within, or do fall within, or read, construed in line with the concept of consequential damages. So you can still recover loss of use if it is a direct loss of use. Or you can still recover loss of profits if it's directly flowing from the breach.
Exactly, and what the difficulty is for contracting parties is they have to make it clear that what they're trying to do is to define what a consequential loss should be for the purposes of the charter party, and again, there's authority, a case called Ferryways and Associated British Parts from 2008 that said if you want to depart from the normal position of Hadley and Baxendale on what the court is going to take to mean consequential loss, you have to have very clear words indeed. That's the quote, very clear words indeed. And there's another case called, it's about a semi-sub drilling rig. It's Transocean were one of the parties to that case, and the vessel's the GSF Arctic 3. And in that case, the consequential loss provision says consequential losses shall mean, and then included different categories of loss. And in that case, the court said, you've done enough there to basically push out Hadley and Baxendale, push out those two different categories of consequential loss, the kind of normal legal position of consequential loss, because you've said consequential damages shall mean, and then listed the things that are consequential losses. Here, they say consequential damages shall include, but not be limited to, loss of use, loss of profits, blah, blah, blah. And I don't know whether the words consequential damages shall include goes far enough to change what's meant by consequential losses under English law. I don't know if you meet that test in Fairways and Associated British Parts of having very clear words.
I don't think you do.
It's marginal. It's certainly marginal.
I don't think. Well, it shall include but not be limited. It's not. It's different to consequential damages shall mean, or words to that effect. It can go either way. I'll give you that.
Yeah, I was trying to think about how the wording would be used in practice. Say I said to you, we're going to have a party with all of our colleagues. We're going to have a party and we're going to have all of our employees, including partners, associates, trainees, etc. I wouldn't be saying that we're going to include every single partner at a law firm in the world. I would be limiting myself to the partners that are also employees. And I'm not sure whether this is a perfect analogy. I'm not sure if it's even a good analogy. But in this context where it says consequential damages shall include, but not be limited to, loss of use, loss of profits, I don't know if they're necessarily saying all loss of use, all loss of profits are consequential damages, or whether they're saying consequential loss of profits will be excluded. Consequential loss of use will be excluded.
I think it's the latter, and that's how I read this initially, and the more I think about it, that's how I'm coming out at this, because the principle that I referred to earlier, where when you list out the different types of consequential damages, that they need to be read within the concept of what consequential damages are, I don't think is amended by this clause, and I don't think I don't think it gets to the level of very clear words indeed, but I don't even think it goes to seeking to change the definition of consequential damages. I read it much more like these are the types of consequential damages that fall within the definition of consequential damages. And if you come at it from that approach and you have that interpretation of this clause, then it's not going to reach that threshold of amending what is meant by consequential damages under the second limb of Hadley and Baxendale.
Yeah, and that's where I get to on it. That's where I get to on it as well. It's one of those where you'd love to read the award, or you'd love to have benefited from seeing the arguments as they're presented, because I'm sure that these points were discussed, and I'm certain there's more nuance to it. But in reading the kind of 2-page summary that we get as a London Arbitration Award, my feeling was that clause, that wording, doesn't do enough to overturn the normal position on consequential damages, and that loss of hire, a straightforward loss of hire under a subfixture, is not a consequential loss. It's a direct loss.
Yeah.
In most circumstances.
That's where I'm coming out at this as well. So I can see where your concern arises. I do think you're right that there's more to this decision than meets the eyes on this summary. I go back to the original point about I don't understand how there were not any specific defences to the owner's claim. And I wonder the extent to which this was argued with the nuance that we're talking about. Perhaps it was, perhaps it wasn't.
Yeah, that's true. You wonder whether all these points were aired, or whether they were just better counter arguments that we haven't found in preparing for the podcast. But it is good law that in certain contexts loss of hire is a direct loss, and equally it's good law that to change the meaning of what consequential loss is, to depart from Hadley and Baxendale, you need to be pretty clear, and I just don't think that they're there.
Well, what it does show is that these cases turn very much on the exact words that are used in the contract.
Yes.
And then the nature of the loss that arises. This is, I know we've got the name case by case and dealing with cases on a case by case basis for our podcast. But this is one. This is one of those situations where you've got to look very carefully at what did the parties put in their contracts in defining or describing consequential damages and what effect it has, and then what's the nature of the loss that's said to fall within that exclusionary clause. And this comes on to, I think, one of the takeaways from this case, and that is at the front end, when drafting these types of contracts, it is worth looking very closely at consequential losses clauses and how they are drafted. Do they intend to change the meaning of consequential damages, the actual definition itself, and how it interplays with the second limb of Hadley and Baxendale, and give that some thought at the outset.
Yeah, and I think there are some good examples of that actually. One of the commodities that we do a lot of work in is LNG, and the BP kind of master sale and purchase agreement for LNG is where it has its exclusion provision. It excludes consequential losses generally, but then separately it excludes loss of income, revenue, production, goodwill, profits, or business opportunity, and separately it excludes exemplary or punitive damages. And separately, excludes a few other things that they seek to exclude from their contract. And what they do well is they delineate between the exclusion of consequential losses as a general category, as the second limb of Hadley and Baxendale, and the other exclusions, things like loss of income, revenue, production. For example, if this contract had simply said, neither party shall be liable for loss of use, loss of profits, shut-in, loss of production, or cost of insurance, then I think you can uphold that quite simply as an exclusion provision. Or even if it had said consequential damages shall mean loss of use, loss of profits. But where it says consequential damages shall include, I think it's referring to consequential loss of profits, consequential loss of use, as opposed to direct loss of use and direct loss of profits, which are still claimable.
Yeah, I see that. I think that's a very good point. Well, another interesting one, Calum. Do you want to sign us off?
Yeah, well, I think it's as you say, it goes to exercise care when you're drafting a consequential loss exclusion. If there are types of losses that you want to exclude, then don't package them in with terms of art like consequential losses, consequential damages, direct losses, indirect losses. Just have them as standalone exclusions. If you want to exclude loss of profits, then just say loss of profits are excluded. It's a much neater, cleaner way to exclude those categories of losses, and it's what we see in some of the industry standard templates, particularly in commodities trades. That's, I guess, the main takeaway. Otherwise, look forward to future episodes. Look forward to the next one. We've now done English law judgments. We've done English arbitration awards. We've done US law judgments. So we're working our way around. And to our listeners, please do follow or subscribe or like or whatever you're allowed to do on your listening platform. It really helps us keep getting the word out. And particularly, please give us some feedback. It'd be great to hear any comments, any constructive criticism for future episodes, or anything that you want to hear us discuss. We'll gladly incorporate that into future episodes.
Thank you for listening. See you next time.
Cheers. Bye.